Hello, everyone, and welcome to Climate Justice in Court, Civil Society and Climate Advocates Driving Change Through the Legal System. Whether you're joining us live tonight or watching the recording later on, we are really glad to have you here. And again, as I said initially, thank you very much for taking the time. We really appreciate it. We don't take it for granted. We often sit here in Ottawa and wonder whether our work is reaching all of you folks across the country. And this is the answer. So we really, really appreciate it. Very briefly, my name is Maryo Wahba, and I'm the Climate Justice Policy Analyst at Citizens for Public Justice. I'm also a JD candidate at the University of Ottawa, so I apologize in advance if there's a lot of legalese out there, given that the three speakers on the panel are lawyers and the moderator is a law student, but I swear we'll try our best to make it digestible. I'll be, as I mentioned, your host and moderator for this evening. And before we begin, I want to offer a brief land acknowledgement, and I trust that our panelists will situate us a lot better in this. We're gathering online from many places, but I am personally speaking tonight from Ottawa, or so-called Ottawa, which is located on the unceded territory of Anishinaabe Algonquin Nation. I extend my sincerest respect to the First Nations, Inuit, and Métis peoples of Turtle Island, and to their ongoing and past and present consideration and stewardship of the land. So a couple of quick logistics. This event is being recorded, and we'll share the recording on CPG's YouTube channel, including as a part of our Give It Up for the Earth resources, which we'll talk about shortly. Please drop your questions anytime in the Q&A or in the chat, and I'll keep an eye on them, and we'll move into a question and answer session for the last half an hour. So don't lose sight of your questions. Write them down, write them in the chat, and we'll get to them. Tonight's conversation is about public interest law and strategy. But nothing shared here is legal advice, even though I'm still a law student. They teach us to say this. None of the following is legal advice. We're here to learn and to discuss together. One quick note before we dive in. CPJ's work, which entails many things like research, advocacy, public interest engagement, like this very event, depends on people like you choosing to sustain it. So if you are able, and it doesn't come at a huge expense to you in this economy, we'll share a link tonight where you can donate to help keep this work going. Every donation, no matter how large or small, makes you a member at CPJ for a year. And that comes with a host of other privileges, like being able to vote on CPJ's future, like our biannual publication, The Catalyst, and of course, the ability to say that you're supporting and helping with this work. And if you want to stay connected, you can also sign up for the Justice e-News, which is our monthly newsletter where you'll stay abreast of all of this. So Michael will drop the links for both the donation page and how to register for the Justice e-News in the chat. Across Canada, we're currently, unfortunately, watching the federal and provincial governments backtrack on climate policy wins, often justified in the name of deregulation and unchecked economic development. That can leave people feeling like the democratic tools we're supposed to use are not enough. But civil society in Canada has a long history of using the courts carefully and strategically and in service of the public interest when governments fall short on their promises. And I want to say this clearly at the outset. The fact that CPJ can even show up in this space today is because of the work that the people that you will hear from, whether historically through John's work and Roger's work, or right now in the present through Glenn's work. So I'm personally very, very grateful, humbled, by sharing the same platform as all of them. And the work that entails decades of legal courage, persistence, and principled advocacy is literally what enables us to be here before. I've said that before. I'm standing quite literally on their shoulders. So thank you again. So I'm very grateful to be here, and without further ado, I'll jump into the content of the webinar. This webinar is a part of CPJ's Give It Up for the Earth campaign, which again, Michael will share the host page, the web page for, which is a national faith in action campaign that helps people reduce household emissions, take solidarity actions, and collectively advocate for stronger federal climate action. There are many actions under the campaign, like calling your minister and your representatives, but the action that I especially want to lift up tonight is to please sign CPJ's open letter, which calls on the federal government to end equivalency agreements that allow provinces to keep burning coal for electricity. If you're joining live, we'll drop the link in the chat, and if you're watching the recording, you'll find it through CPJ's Give It Up for the Earth page. So signing only takes a minute, and it's one of those small actions that becomes powerful when lots of people do it together. So please do sign the open letter whenever you have a chance. Now I'm genuinely excited about tonight's lineup, and I want to name again how grateful I am to the speakers who are giving us their time. First, Glenn Wright. Glenn practices law at Procedo LLP in Saskatoon. He transitioned from engineering into environmental litigation, engineering and farming, I shall say, into environmental litigation. He still is a farmer to this day. He's representing CPJ and our co-applicants pro bono in our Saskatchewan coal case because he believes that it matters for the rule of law, transparent decision-making, and aligning Saskatchewan's electricity future with net zero as soon as possible. Glenn also brings a lived practical perspective from rural Saskatchewan on how clean energy and electrification can actually look on the ground, including for rural household and farms. And second, and this is truly an added bonus for us, we have HW Roger Townshend, who is a Senior Counsel at Olthuis Townshend LLP. Roger is a longtime CPJ member, and he has served as CPJ as both a board member and a board chair. He is a seasoned litigator with deep experience in Indigenous and constitutional law, and he'll be offering additional reflections and context that I think will help connect the legal strategy dots for a lot of people who are in a very, very grounded way. And he will also enlighten us about a part of CPJ's history that I can tell you I wasn't privy to, what CPJ did in the way of strategic climate litigation and Indigenous solidarity public interest cases early on. Third, and certainly not least, John Olthuis. John is one of Canada's leading Indigenous rights lawyers and a CPJ co-founder. In 2023, he was appointed a member of the Order of Canada, which is one of the highest civilian honors that you can have in Canada. He continues to represent First Nations across Canada in litigation and major negotiations. John's new book, which we'll hear about a little bit more, is called On Dismantling Settler Colonialism, and it's available through CPJ, and we'll share information tonight about discounts for faith communities or study and action groups that want to engage the book together. Again, it's not lost on me that this kind of wisdom is hard won, and I'm grateful to stand with you tonight and learn from you. Glenn, thank you again for joining us. I'll hand it over to you.
Sorry, just had to unmute there. Thank you so much, Maryo. And I'm coming through okay? You can hear me all right? Good stuff. Well, thank you very much for the invitation here to speak tonight about climate justice. My goal here is to tell you a little bit about how I came to this kind of work in the first place, because I think it's a bit strange to see an engineer change careers and move to this. So maybe the personal story will give you some insight as to how I came to do this. And then I've got a short slide presentation of about 6 slides that it'll take me just 10 minutes or so to go through that. So for me personally, I started my career as a mechanical engineer, actually working for oil and gas in Lloydminster, Alberta. And so I started out as a pipeline engineer in the terminal there at the refinery. I was responsible for, helping work on the gathering system that brought heavy oil to the refinery. Then I got transferred to production in Rainbow Lake in northern Alberta. And I always had this sort of sinking feeling, just digging at the back of me, that this industry is not doing right by the environment. And I distinctly remember a large sulfur block that we poured in northern Alberta in Rainbow Lake. And back in the 90s, then there wasn't as much focus, I think, on environmental regulation. I do remember a big kind of dead zone where the runoff came from that sulfur block and it killed trees and vegetation. And it always was unsettling to me that I was working in this industry that was having an impact on the environment. But it was not until 2006 when I saw that Inconvenient Truth movie by Al Gore that I realized that the climate issue was just such a devastating issue that we had to address. And I probably spent the next 2 years of my life reading material, hoping to disprove, the facts of climate change. But of course, the more that I read, the more I became more concerned. And so I at first turned my focus on public policy to, after spending some time trying to decarbonize our own lifestyle and our own house, it occurred to me that no matter how good I was behaving as an individual, we needed collective action. We needed everybody doing something in order to try and address our environmental crisis. So I actually tried my hand at politics. I was a political candidate in 5 elections from 2010 until 2020, both provincial and federal elections. But as you know, the climate is only one issue, and the environment is only one issue of many in politics, and our political system doesn't seem to address what we need in terms of policy for climate change. So around 2016, where I was starting to realize this, is when I retired from being an engineer, and I decided to go to law school so that I could become a better advocate for the environment. So I started law school when I was 41 years old, and I got called to the bar in 2021. And I guess I was, at first I thought to myself, if I really wanted to pursue climate litigation, I'd probably have to have $250,000 to hire a lawyer to do it. Or I could go to law school, and it cost me about $50,000 to get a law degree, and then I could do it myself. So I just thought it was probably more something I could do in my direct control with less of an investment. That's why I went to law school. But the final thing that I guess persuaded me or convinced me I was on the right track, I happened to be fortunate enough to go to COP26 in Glasgow in 2021. And while I was there, I went to a presentation that was put on by the lawyers for the Milieu Défensif versus Royal Dutch Shell case. I see John nodding his head. Some of you may remember that case. It was a very important turning point in the world of climate litigation, that a private entity like Royal Dutch Shell had been held to account for their impacts on the broader climate. So meeting those lawyers was very impactful for me, because they talked to me and encouraged me to try and do the same type of thing in Saskatchewan. And so that was really the nexus of us trying to organize around how are we going to pull together some people and challenge the government of Saskatchewan for inaction on climate change. And really, this is about supporting the rule of law. And so I'm just going to share my screen now and get into these 6 slides that I talked about. And just bear with me for a moment. Hopefully this comes through. Are you able to see that okay now? Should be an ours to protect. Okay, good. So the law societies of Saskatchewan, or of every province actually, they've kind of joined together and kicked off this campaign about the rule of law. And the campaign is called Ours to Protect. So if you're interested in that campaign, you can go to that website and look at it. But really, this is about trying to support and encourage more confidence in the public about our rule of law. Because all around us, we see the rule of law being eroded, not only with misinformation in the public, but also with governments in Saskatchewan and Alberta using the notwithstanding clause to try and roll back the protections we have under the Charter of Rights and Freedoms, and sometimes not following our constitutional law here in Canada. And so this is important. We need the rule of law because, from my perspective, there's really only two ways to wield power, and that's either through violence or through diplomacy and democracy. And the rule of law is an important pillar of holding up our democracy to make sure that we can, come to compromise and diplomacy through civilized means rather than resorting to violence. I'll just try to advance the slide here. So when we talk about supporting the rule of law here, this is about transparency and equality and making sure that no one is above the law, especially our governments. And so the Cole decision that came out in Saskatchewan in June of 2025, after 15 years of the government of Saskatchewan saying, hey, we're going to phase out coal, they did a complete 180, an about face, and sent out a letter to the employees of Saskatchewan Power, which is our Crown Corporation. It's a government-run power utility. That letter said, hey, we're going to change our mind and we're going to run coal until 2050. We're going to refurbish those plants and keep them operating long beyond what was the federal law saying they had to be shut down by 2030. So thankfully, a CPJ stepped forward as one of the applicants willing to be someone to be the applicant challenging this decision, along with the Saskatchewan Environmental Society and 3 other individual applicants. So we filed an application a month later on July 18th. We're arguing that this decision is both unreasonable and unlawful. And we're also saying that the constraints that should have been considered by the government, we don't know that they actually even considered charter constraints or economic reasons. Really, that decision to advance this coal to 2050 is a decision that seems to be not justified, or at least not in a transparent manner. So what we're trying to do is hold the government of Saskatchewan accountable and get them to disclose to us what other choices they might have considered or how they can justify this decision as being the only alternative that we have. And so I had hoped that there would have been a hearing on the merits of the case, but the government, generally what they do in all of these climate litigation cases, they try and delay. And so in this case, they had filed a preliminary motion to strike the case, saying it was not justiciable. And so we had a hearing for that on November the 10th, and then the decision was released on January the 12th. We are now appealing that decision. We've only filed the notice of appeal, but I expect that we will probably be before the court appealing this decision likely in the fall of this year. And so if you do have any more questions about this case, the legal documents are actually filed at that website. So if you want to get more of the nitty gritty, actually see some of the papers that have been filed at court, that's where you can go. And so I have to also mention the Dykstra case, which is the case that we first filed in 2023. And so long before the coal decision, back then in 2023, we all understood that the Saskatchewan government would be ending its reliance on coal generation by 2030. But of course, that didn't happen. But at the time in 2023, we had thought the best way to challenge the government of Saskatchewan was to do a charter challenge. And so the coal case I mentioned before is an administrative law challenge. We're specifically challenging that particular administrative decision to extend coal. Whereas here in the gas case, we filed a charter challenge saying that we think the state action to expand natural gas generation violates our charter rights to life and security of person and potentially equality rights for young people because they'll face more burdens related to climate change as time goes on. In this case, again, they did the same thing, trying to delay the case as much as possible. So there was a preliminary hearing on October the 4th of 2024, like a year and a half ago. And the decision took more than a year to come out. We didn't actually get the decision to strike the case until October 10th of 2025. And then we served a notice of appeal just before Christmas. And actually just today, only about an hour and a half before this webinar started, we've got a date now for the appeal hearing, which is going to be on April the 17th. So thankfully, this will be going to the court relatively quickly because quite often they're scheduling things out 6 months in advance. But I'm pleased to say we will be on the Court of Appeal for this Dykstra case 2 months from today. Now, getting back to the rule of law, I think what's undermining the rule of law is misinformation. And some of that misinformation is coming directly from provincial premiers who are saying that, perhaps we can only run our province with coal, or they're challenging us, telling the public that EVs don't work in Saskatchewan, or that heat pumps don't work. And we see disinformation and misinformation being spread, undermining all of our faith and trust in the government and the rule of law. And you see that even with things like the ostrich cull, the ostriches that had to be culled for the bird flu issue in British Columbia. You see it also with respect to vaccines and how people are losing faith and trust in the effectiveness of vaccines. So really, even our Chief Justice, and that's what I wanted to highlight on this slide, our Chief Justice of the Supreme Court of Canada, his name is Richard Wagner, and even the Chief Justice has written articles in the Canadian Bar Association saying that disinformation is really undermining people's confidence and trust in the rule of law. And so that's why it's important for us to call out others when we know they're saying something that isn't true, especially in the public discourse, in the public dialogue. It's important to respectfully try and challenge that and not allow the disinformation and misinformation to spread. So this brings me to climate change. This is the second last slide I have. But really, we've seen a lot of people trying to suggest that climate change isn't real, or to say that it's a hoax. And even President Trump in the United States is one of these people that's doing that and saying that green energy is a scam. But I think it's important to remember that our Supreme Court here in Canada found as fact, this is uncontested fact that the Supreme Court has found, that climate change is real. It is caused by greenhouse gas emissions that result from human activities, and it poses a grave threat to our future. The only way to address it is to reduce greenhouse gas emissions. And so this to me is no longer up for debate. This is part of what we're relying on in terms of precedents to support our cases. And that's why I like to try and make people aware of it whenever we have meetings like this or presentations. People need to know what the Supreme Court has said. And that's already 5 years old now. And so in closing, I look forward to questions. We certainly have a lot more to talk about. But with respect to climate change, I think it can be boiled down into this simple thought here, that to stop dangerous climate change, it is necessary to replace fossil fuels. And it's mostly sufficient to replace fossil fuels. So often we get distracted with other things like vegetarianism and so on. But really, the main problem associated with climate change is our burning of fossil fuels. And so that climate literacy that we need more and more people to recognize that fossil fuels is causing the problem. And that's why we've pursued these two pieces of climate litigation in Saskatchewan. One challenging the expansion of gas generation, and the other challenging the decision to run coal to 2050. So subject to questions later on, I think that's the end of my presentation, Maryo, and I'll hand it back over to you.
Thank you so much, Glenn. That was incredibly clarifying and sobering when you talked about disinformation and misinformation. And I know I can say with complete honesty, I've really, on a personal level, enjoyed working with you, Glenn. So thank you, and I hope a lot more of that to continue, and hopefully with some wins that come our way. So now, Roger, thank you again for joining us tonight, and thank you for your long-standing leadership with CPJ. I'll hand it over to you.
Thank you, Maryo. So I'm coming to you from Toronto, and want to acknowledge the treaty and traditional territory of the Mississaugas of the Credit First Nation. I'm pleased to be here. I've been a CPJ member since the early 1970s, and in fact, CPJ was one of my entrees to social justice issues, and I found it very inspiring. I was chair of the CPJ board for a few years in the 1990s, and what I've been doing for the last 30-some years, I'm an Indigenous rights lawyer. I have done some environmental litigation, not recently though. And John and I were founders of the firm Olthuis Townshend, which is almost now it's almost entirely Indigenous rights firm, for a while there was more environmental law. We still do environmental law for Indigenous clients. Earlier we did environmental law for other clients as well. But I'm very pleased that CPJ is involved in climate justice. It's one of the crucial and signature issues of our time, and absolutely essential to deal with, and also to be involved in this case. And I'm so glad to hear what Glenn has been doing. So I mean, as Glenn was just skimming over some of the stuff of the case. I mean, I do have a few questions for Glenn that he may want to address in a little more detail. One of the bases of the case was that what Saskatchewan was doing was inconsistent with the federal clean energy regulations. So I just wondered if there had been any attempt to interest Canada in being part of this appeal. That's one question. Another is if it would seem you could have the case wasn't framed this way yet. It was framed on what was considered and what wasn't considered in the course of making this decision by Saskatchewan. And we couldn't really tell what was considered, what wasn't considered, because the case didn't get far enough there. Saskatchewan has not produced its record of the things that it did in the way of that. But if you're looking at more of the substantive conflict between what Saskatchewan did and the federal clean energy regulations, there would be an argument, it seems, and I'll be interested in Glenn's thoughts on this, that the federal regulation is paramount. Now there is, of course, there's a significant constitutional hurdle that provinces have exclusive jurisdiction over non-renewable resources and their extraction. So I'd be interested to see what, maybe that's why Glenn didn't deal with that head on. He sort of went around the edge of it a little more. Be interested to see what he has to say about that. And another thing I noticed about one of the reasons that the first level court bounced it out was saying, well, this isn't really a decision. It's just a policy announcement. But when you read the letter that's the subject of this judicial review, it says it's a decision. We've decided to do this. I don't know how the court could think it wasn't a decision. I mean, maybe Glenn has some more insights about that. So that's really all I have to say at the moment. I'm happy to be here and happy to hear what Glenn has to say and what some of the others of you have to say on the line. And I think I see some people on the line that I knew 50 years ago. Anyway, thank you. And I'll sign off now. You can go to John or you can go back to Glenn for answers. It's up to the moderator now.
I'm glad that we're having a little CPJ old club gathering. That was partially the intended objective. No, I love the fact that we have a little discussion inside of the discussion. So please, Glenn, go ahead.
Well, it's complicated, and as lawyers always say, it depends. I know the audience maybe doesn't have focus on the legal background that John and all the presenters here do, but I think the real key thing for us here is, as you mentioned, Roger, is the letter is kind of a wide-ranging letter in that it has some policy aspects to it, but it also characterizes this as a decision in 3 places, I think. And so that's what prompted us to go down the road of using an administrative law judicial review, because we thought this was a very specific decision. And shortly after the letter came out, there was an announcement by the government they were spending $900 million to refurbish these coal-fired power plants over the next couple of years. So not only is it, broad policy that we're going to rely on coal, but there are specific actions taking place that are already being implemented. And so I think the other thing you mentioned, Roger, is that there just wasn't a lot of transparency. That there isn't a record, as we call it in the legal terms. We haven't seen disclosure of how they came to make this decision, which is also a radical departure from the prior 10 or 15 years of policy where they were planning to shut down coal by 2030, and they had signed agreements with the federal government. You mentioned the federal coal regulations and how there could be a paramountcy argument that those regulations are, override what happens in the province. But they've also signed equivalency agreements under the Canadian Environmental Protection Act to make sure that those regulations don't apply. And that's part of how they weaseled their way around this. When we had our first hearing, the counsel for the government kept saying, well, we're not breaking the law yet. And they kept going, well, the law won't actually be broken until 2030. But gosh, if our legal system can't be forward looking enough and can't recognize that these are long-term projects that take several years, then what can we do, right? We need our system of law to be proactive and recognize, call a spade, I suppose, that just because you're not breaking the law yet doesn't mean that we're on a pathway that is unreasonable.
Thank you, Glenn. And I see the hand up, Brooke, and I'm delighted to know that there are questions swirling around. I just would be remiss if I don't let John give us his presentation, and then we have 30 minutes at the end for Q&A, and all of us will get to ask our questions, or at least I hope so. And so again, John, thank you for being here. Thank you for this answer, Glenn, and thank you, John, for being here and for the decades of work really that have shaped so much of what many of us now call reconciliation and justice, and often without realizing how hard fought these fights were. I'll hand it over to you, and please feel free to connect the dots between Indigenous rights litigation and the realities of the current realities of reconciliation and climate justice and what it requires from all of us. I know that's not an easy task. John. Oh, I think you're still muted, John.
Okay, I thought you were unmuting me. You're in control.
I'm sorry. I'm sorry.
Okay. Well, I'm also like Roger, acknowledging the Mississauga of the credit land that I'm on, and gratefully so. Thank you, Glenn, and thank you, Roger, and yeah, it's exciting for me to hear about this challenge. A long time ago, I was a CPJ staff member back in the mid-70s, which for many of you are kind of the Middle Ages, and a long-time CPJ member as well and supporter, and very grateful for all the work of so many, including CPJ and the Saskatchewan Environmental Society, on this on climate justice and this specific challenge. I was probably, like all of you, dismayed by the decision of the court not to hear the challenge, based on, their, before even I gather hearing much of the argument that the court couldn't review a government's decision. And I agree with the statement of your 12-year-old petitioner. I guess it's K.K. Dyke, if I'm pronouncing that right, who said that the decision is not just. As I also believe the decision to extend the life of these three coal mines is a threat to the health and well-being and the physical environment of the people of Saskatchewan and your neighbors. I thought the media attention to the case was great. and I'm very happy to hear that it's being appealed. Narwhal also had a very interesting piece on the case, the CBC, and regardless of the outcome of these cases, the media attention makes an impact. Makes an impact on government. It makes an impact on concerned citizens, and so all of that's very good. I would be interested probably on another discussion that maybe we could have of just the actual grounds for the appeal. I mean, the whole issue of whether or not a provincial government can simply ignore federal policy is an interesting one to me, because specifically because of the cases you referred to, the greenhouse gas emission case, in which Supreme Court has said, the POG head of power, the residual power, is the basis on which Canada can regulate, and the Hydro-Quebec case about the federal government could use criminal law actually to regulate toxic substance release. And then there's the Alberta Impact Act assessment case, in which the court struck down some of what was in that Impact Assessment Act, but the federal government has now, made those changes, and it'll be interesting to see what whether Alberta challenges that. Even though legally speaking, there may be issues with environment being a responsibility of the federal government through the peace, order, and good government provisions. It seems to me that this is an important issue to be raised publicly, and that there are these court decisions, and that it makes common sense that peace, order, and good government has to include climate justice and protection of the health and environment of future citizens of the country. And I think it's a particularly good time to raise this issue publicly because of, the Carney government's new approach to, building a better Canada, and that Carney's approach to a value, because of the Trump threat, we have to move to a value-free kind of public policy. I mean, under Trudeau, there was some value infusion into public policy, and now it seems to be, economic growth at all costs. But I think it's a very good time now to, as part of this whole climate justice initiative that CPJ and others are involved in, to kind of raise Carney has actually now introduced kind of a structural component. Up to this point, and I've always, had these discussions with climate justice folks that, it's okay to be looking at shifting the emphasis to reducing emissions and shifting to clean energy. But those are only they're not really structural changes, and I think Carney's introducing this new approach to really doing away with environmental assessments. And at a negotiation table last week, there were representatives of this new federal agency that were there, and they confirmed very much so that yes, there is at the best going to be one environmental assessment for these major projects that are determined to be in the public interest. And in most cases, it's going to be a provincial environmental assessment. So I think it's a good time for, CPJ and others to be raising, since Carney's raised this as kind of a structural thing, that it would be good to start challenging that, and to say that we need to kind of adjust climate policy in which emissions and impacts are considered as primary considerations in the decision-making process. The way it works now, and has always really worked, is that technical and financial considerations are the primary considerations when projects are approved, and then there's a little bit of attention and afterthought to how can the impacts of the decisions made on technical and financial considerations, how can those be mitigated? And CPJ has this history, of course, with the Mackenzie Valley Pipeline and so on, in which we did something similar. We proposed a just energy policy in which 8 different considerations we proposed would go into the primary decision, along with technical and financial considerations of whether projects should actually go ahead. And some of you may recall that because of the Berger Commission and the work of CPJ and worked with in coalition with some of the Project North and the churches and other concerned groups, 183 groups signed on to this proposal for a moratorium on the pipeline. And Berger recommended that moratorium, and then Pierre Trudeau actually imposed the moratorium on the pipeline, and that pipeline was never built. And it seems to me that it's time, like, for the climate justice movement to start talking maybe a little more about this. Because of Carney's opening to that, he's saying, I'm going to make even further structural changes to the way we do things. It may be time to say, well, we need a more fundamental structural change. We need to take these climate change considerations, along with Indigenous and other considerations, right into the decision-making, the primary decision-making. And I think there'd be, occasion for public appeal and interest and media attention to that, combined with the work you're doing that you'll be doing on the appeal. And at that time, we brought before the National Energy Board at that time was, supposed to decide on public sort of public convenience and interest, and the whole question is, well, what's in the public interest and so on. And we brought church leaders like Primate Scott, economists like Mel Watkins, constitutional experts like Peter Russell to testify before the National Energy Board, which is very, very interesting exercise about the fact that what we need is this different, fundamentally different decision-making process. And I would suggest that maybe CPJ and other groups, respond to Carney's more recent changes by taking a look at suggesting some more structural changes in the way we make decisions about projects, so that we get more focus on emissions and climate change. So I'm very, very grateful, Glenn, for your work on this, and for Saskatchewan Environmental Society and CPJ, and wish you all the very best and strength and blessings as you pursue this appeal and the Dykstra one as well. So thank you very much. I would, if I am quite interested in the POG POG is, of course, the peace, order, and good government residual provision in the Constitution, since the environment was not a head of power in 1867. But I just today did look at some of those cases, including that Hydro-Quebec case and the greenhouse emission cases, where the Supreme Court has said, no, the POG head of power can be used to regulate things that in the provinces. So the question I would have for you, Glenn, is I'm sure you've given consideration to that and looked at these cases, and also the Impact Assessment Act decision on the Alberta challenge. So could you just say a few things about using that as an argument in the appeal?
Yes, I can say that we've considered. Well, I should actually go back a step. When that greenhouse gas pollution pricing reference case went to the Supreme Court, I was still a law student, but I organized an intervention. And so there were 10 civil society groups that intervened at the Court of First Instance, was actually the Saskatchewan Court of Appeal. And then there was the Ontario Court of Appeal and the Alberta Court of Appeal, and all went to the Supreme Court of Canada. So our intervention was one of many, but there were many interveners who were arguing all sorts of constitutional powers that could be applied. So as you mentioned, John, the environment was not a defined head of power, because in 1867, when the Constitution was written, the environment was seemed to be limitless in Canada. We had just an abundance of land and resources, and it was all about, extracting those resources and shipping them back to the motherland of Britain or France. And that's really the colonialist mentality. But when we were at the greenhouse gas pollution pricing case, we were, as an intervener, arguing the charter, saying that the charter right to life is engaged when the government is going to allow greenhouse gas emissions to just get worse and worse and worse. But that what the case ultimately was decided on was this residual power of the Constitution of peace, order, and good governance. Interestingly, though, I think the David Suzuki Foundation, their intervention, they were arguing the emergency powers. So for the people who aren't lawyers on this call, the Constitution has all of these defined heads of powers, things like health and education and banking and taxation and so on. Just a second. May I get you to stop that for a second? I'm on the call. Sorry about that. But it's just our cleaning staff coming in here, because it's about 6 o'clock here in Saskatchewan. But any of the powers that aren't defined in the Constitution, there are these residual powers that come into play. And so one of those residual powers is kind of an all-encompassing thing called peace, order, and good governance. And that's what was found to ground the regulations being constitutional, or VIRES is what is called for the greenhouse gas pollution pricing. But the David Suzuki Foundation said this could also be an emergency power, because when there's something like a world war, then you can invoke the emergency power to give the federal government power to act to address the emergency. So theoretically, climate change, the Government of Canada did declare a climate emergency in 2019, but it was really just kind of a notional thing, or just in language only. There hasn't been a lot of action to back it up. But if we had something like a response like we had to World War II, where we invoked the emergency power and we started using that power until emissions started to decline or were under control, I think that would be valid. The other constitutional powers that were argued was the criminal law power and the taxation power. But the court, the Government of Canada was saying this isn't actually a tax when they were talking about the pollution pricing scheme, because it was more of a fee and dividend. So kind of more in line with like a recycling deposit on your pop cans, for instance, kind of a fee and dividend. It wasn't meant to generate revenue for the government. So it's very complicated, all the aspects of the constitutional law, but sorry, I'm rambling.
And did you get to raise those issues at all before the court said they wouldn't hear? Like, how were you able to make some submissions along these lines, or before they said no, we we're not going to hear this?
In the greenhouse gas case, yes, the court was actually very generous in letting almost anybody in to intervene. And so, yes, at the Court of Appeal, we had 15 minutes to make our submissions, and we focused on the charter and the right to life, and how the charter should be engaged with greenhouse gas emissions. But the court didn't address that. And at the Supreme Court of Canada, we had 5 minutes to make our submissions, and we did the same thing. But again, the Supreme Court didn't comment on how the charter might have be engaged here.
Right. Okay. Okay. Thank you.
Well, thank you, John. I am learning a lot. I'll try to hold on to some of that knowledge as much as possible for my law school classes. But you folks are experts, and to other non-lawyers, if it's going over your head, that's my experience too. So that's fine. I guess we'll try and understand it together over the next half an hour, just very, very quickly, so that I can honor Brooke's hand. John just published a brand new book, and it's called On Dismantling Settler Colonialism. And John's book challenges assimilation-style approaches to reconciliation and calls for real political, economic, cultural, and land-based spaces for Indigenous nations to self-govern and live in relationship with the earth according to their own values. We'll share the link, and CPJ can offer bulk discounts for groups that want to read and take action together as a study and action group. So please, if you can, if you're interested, buy that book. Thank you, John Heemstra here. I see already has a copy. If you can and interested, buy that book from that link. That will also support CPJ, thanks to John's generosity. And now the part that we're all excited about, Q&A, and I can't keep you waiting any longer. Brooke, please go ahead. Oh, you're muted, Brooke. And I'm sorry, I actually can't unmute folks. There you go. Oh, Brooke, you're still muted.
Okay. Hi. All right. Right. I'm. Thank you very much for all of that. I'm not a lawyer, but I certainly did understand some of it, and I really think it is important to use the law. What I wanted to say though is that I know that the law arguments for the law and science and economics are always used to persuade governments there is a climate crisis and what can they do. And I realize these are very important and practical things to use. But I'm just thinking, I mean, Mark Carney, I belong to a group called Seniors for Climate Action now, and also Faith and Climate Action. I'm not actually religious. The reason I belong to Faith and Climate Action is because they have moral courage, and they talk about ethics, which is very rarely mentioned in terms of the climate crisis. I also I'm into civil disobedience. I've been arrested a few times, and I just think also that is an important thing to do. But the question I have is, have you ever considered that Mark Carney is a devout Catholic? And I'm just wondering if you've ever brought up issues of ethics, that it is ethically wrong to colonize Indigenous land and ethically wrong to destroy the planet. And somebody brought up an issue about fossil fuels cause much more harm than, say, industrial farming or vegetarians. But industrial farming also destroys creatures, live creatures. We are animals too. And and often these issues of ethics is not brought up, and I do think it's important that rather than just saying, oh, it's expensive, oh, it's against the law, oh, it's going to destroy the common economy or whatever. It's actually destroying the planet and destroying all the creatures in it, including industrial farming and everything. So I don't want to give a lecture, but I mean, I just think it's something that I don't hear very often in these arguments about climate crisis. Thank you for letting me talk.
Thank you, Brooke. I can tell you from our lobbying efforts at CPJ that ethical arguments, unfortunately, do not take you so far, but it is not up to me to answer. I'll leave it to any of the three panelists. If you also want to talk about the sort of like how to bridge those ethical stances to either legal or other arguments in order to make it in front of the court. So yeah, I'll leave it up to the panelists.
I'll just make one comment. For me, it's always been love of neighbor, the fundamental principle of love your neighbor. I became a lawyer because my father said to me, look, there's all kinds of ways of loving your neighbor. So I got into law and discovered very quickly that the law doesn't care much for the marginalized people or the earth. So that's when I quit after 2 years and eventually started working for CPJ on the Mackenzie Valley pipeline and so. But for me, I always ask the question: is the action that I'm taking or part of is it really showing love for neighbor? And if not, I don't want to be part of it. And I think that's a fundamental issue for political people too. When you confront political people with love of neighbor, in pretty well every faith community, whatever faith it is, has that fundamental principle. And I think we need to appeal to them with that simple saying, no, this isn't loving your neighbor, and your neighbors include all the creatures in the land.
Of course. Unfortunately, the government politicians often don't act on that
That's
principle.
right.
But thank you.
Mm-hmm. Thank you, Brooke and Nancy. It's an honor and a pleasure to have you here. Please go ahead. Oh, I think you're still muted, Nancy.
Are you there? Can you hear me now?
Yeah.
Yeah.
Yeah, perfect.
All right. So I'm a lawyer as well, and I appreciate the work that's being done. And
Nancy's the partner, the clear and
I'm the K. I'm the K. It's okay.
The K.
So one of my questions is as a member of CPJ and as a lawyer, I mean, I do other things outside of law as do most lawyers. One of the sort of burning questions for me is, obviously climate change and climate response to climate change has dropped off the agenda of the government of Canada in a big way. And how is it, has CPJ been coordinating with, or are you interested in, or are you pursuing coordination with civil society groups across the country to find a way to bring it back to the forefront politically for Canada so that it becomes something that they can't ignore? Obviously we've been seeing what's happening in the United States with the ICE agents and the horrors there, and people have responded because people were killed. That seemed to be the thing that turned people around to say, we cannot do this anymore. And the people of Minneapolis have been joined, across the United States and in Canada and other places around the world to say, this has got to stop. And I just challenge CPJ to think about how is it that we can build a coalition politically that cannot be ignored. Singing Resistance has joined and made a huge impact in Minneapolis. People are singing around the world because things need to be done. Things need to change. Well, things need to change for climate justice as well, and it has to get on top of the agenda again. So I'm asking CPJ, have you been pursuing that kind of thinking to raise it on the political agenda for Canada?
Yeah, thank you, Nancy. That is really the $1 million question. At the beginning, my remarks included, again, a similar sentiment, the regret that the drop or the reduction in the priority level of climate justice on the political sphere. But it is hard to think of a silver bullet for an issue that's as intricate and multifaceted as this. I mean, I can point to our work with the Climate Action Network, which is by far the farthest reaching. A coalition of environmental groups contains about 180 member organizations around Canada. And really, with all honesty and sincerity, I can point at the work that Glenn is doing. I mean, as John already mentioned, the amount of national media attention that this case brought up at such an early stage as well. In terms of forcing not just the Premier of Saskatchewan, but also the Minister of Environment and Climate Change on a federal level to defend the equivalency agreements publicly, whereas nobody knew what the equivalency agreement was. To Glenn's earlier one of earlier points, when they submitted a consultation submission, when they opened the consultation submissions for that equivalency agreements, they had zero comments because there was no public awareness or knowledge that it's happening. And I can point to tonight, I think all of you are messengers, all of the folks on the call are messengers that will hopefully take this message and amplify it beyond us. But I view it, in order to not be hopeless and cynical at the end of the day, I view it as an exercise of building forward momentum. And I think that every little push adds to that momentum. And there's a part of that closer that alludes to that as well. And I think it's just a persistence, again, an exercise in persistence as well. It was waking up every day and thinking what I call at CPJ, in my sort of realm of decision making, windows of strategic opportunities. And so what window of strategic opportunity can we jump on? And when Glenn called or emailed with that case about Saskatchewan, that was one where I said, okay, CPJ needs to be in on that. So yeah, I see Glenn will probably have a much more wise answer than this.
Well, I don't know if I have a wiser answer, but if I contrast the two cases, I think you're absolutely right, Nancy, in that what we need to do is drive the public narrative, because politicians don't seem to respond unless there's a public pressure forcing them to do something. Politicians like to jump in front of a parade that's already formed. And so this is one of the pieces of tidbits that I took from those lawyers on the Shell case that I met in Glasgow. They said, what happens outside the courtroom on this kind of litigation, this public interest litigation, is often more important than what happens inside. And so we need to take these opportunities to be driving the public and getting in front of the media and talking about it. And that's why I think this coal case actually has more opportunity to do that than the gas case. Because generally, I think the public knows that coal is the most dirty way to produce electricity. And furthermore, they know that coal causes health problems like asthma, or COPD, or air quality. They know that coal kills. And I think back to how the public narrative changed on cigarette smoking. Cigarette smoking, all this health information came out about how bad cigarette smoking was for the people smoking. But it wasn't until we found out that secondhand smoke was killing people. And so there became this unfairness to it, right? That it wasn't just the people smoking, but it was everybody being impacted. And that sort of really started to coalesce all of the support for trying to do tighter regulation to close down smoking in public places like restaurants and bars. And so I think if we can sort of draw that parallel here, that coal and burning coal in Saskatchewan, where Saskatchewan may benefit, is going to cause tremendous harm to people in Manitoba and Ontario who are downstream breathing in all of that toxic pollution. And that unfairness of it, that Saskatchewan is undermining our national objective to try and decarbonize electricity. I think that could have some really important influence.
Can I just say one thing? Short slogans. Coal kills. Coal kills. Make that your campaign. Coal kills. Anyway, just a thought.
How about no more coal in Canada?
Not
as short. Okay.
Coal kills. You want something short that people can put on a sign and get excited about because it's real and it's true and nobody can deny it.
I'll pitch
Anyway,
it
I
to,
just that's my thought.
No, thank you, Nancy. I'll pitch it to our communications coordinator when he's back from vacation. But no, thank you. Again, very insightful. I am personally learning a lot. Any other questions? I have one if folks are, and if there are questions in the chat, please feel free to alert me. I've been trying to keep an eye, but I don't think I see any fully articulated question. Okay, so I have one that I prepared for. Oh, please, Jen, go ahead.
Do you hear me?
Yes.
Well, I'd like one of the panelists to comment on Enbridge. We know that Enbridge does not have a good track record in its safety precautions, and there's been a lot of litigation among Americans against Enbridge, which really should concern Canadians, because one of the court cases involves the Bad River Band in Wisconsin, and there are also citizens in Michigan who are also in litigation. The Enbridge wants to build a tunnel underneath the Mackinac Straits, where Lake Superior connects to Lake Michigan. And if this tunnel is built underneath the straits, it's already been, the assessment has already been done saying that it should not be built, but Enbridge is determined to go right ahead and have it built. So I'd love to hear comments on that.
John or Roger?
I only know a bit about that case. As I recall, and I haven't checked it for a while, that was they had the current line goes right through the Bad River Reserve, and the lease to that expired, and the tribe was saying no, you can't go anywhere. So I think their plan is just to make a big detour, which is going to cost them more money, but it's not going to shut down the pipeline, line 3, I think it is. The other thing about the Straits of Mackinac is, at present, there's already pipelines passing under the Straits of Mackinac, and it's. I mean, they're pitching it. A tunnel would actually be safer. There's things to be said for and against that, but there's it's already coming across there, and there's this scare tactic going on that the refineries in Sarnia are all fed by this line 3. So I mean, there's sort of this scare issue that say, well, then Southern Ontario is going to be cut off from oil. So I mean that's some of the back and forth, and there are and First Nations in Canada have come down on different sides of that. But I'm not really up on that. I'm just telling you what I remember. It's kind of off the cuff here. I don't know if anybody else. Nancy, do you know about that? Nancy's actually a real environmental lawyer.
I would like to add that a movie has been made entitled Bad River, and the movie really goes through the history of this particular court case against Enbridge. So that's one simple way to gain a lot of information, and it's still before the courts, so the story hasn't ended yet.
Thank you, Jen. And Nancy, I don't know if you want to... Please go ahead.
I was just going to make a short comment that the fact that it costs them more money is relevant. Like everything, you can win on the principle, or you can win on economic grounds. And winning on economic grounds is a practical way to get the result you're looking for. And, that's one of the things. To make things more expensive is one angle to pursue. And how do you make things more expensive? And this is going back to John's comments. If mitigation is going to be too costly, then it's not an option. And then you look at other options because businesses are interested in making money, and they look at alternatives if they can't make as much money. So that's a sort of a longer term approach, not longer term, a sort of a broader scale way of thinking about the problems. How can you make something that is polluting, that is causing climate impacts, economically unviable? So I just make that comment.
Okay. Thank you for all your comments.
Thank you. And I see in the chat there are two sort of simmering discussions. Comment from Kathy. Cole also raises equity questions because some provinces and their residents are paying to get rid of coal, while others are undermining their investment by continuing to pollute. Is there a way to use inequity to raise the profile of the issue? Yeah, I always in my op-eds and whenever I write articles about this legal action mention the fact that Alberta has basically gone off of coal in I think 2023, and Ontario has been off of coal since 2015. And so other provinces, as Kathy mentioned, are absolutely doing their fair share, while Saskatchewan is not. Any comments from our other panelists about how to leverage that from a legal standpoint?
Well, I guess I would tie into the cases that I think it was Jen brought up about Bad River in Wisconsin. The amount of litigation that's happening around the environment and climate is actually growing exponentially. So 5 years ago, there may have only been, a few hundred cases, but now we're seeing thousands of cases around the world. And some of those cases, though, are talking about liability. And even in the COPs meetings themselves around the Paris Agreement, they use words of loss and damage. But in reality, what I think those words mean legally is liability and compensation. And so as we start to think about how Saskatchewan may be, getting a free pass right now on emitting, being the highest emitter for our electricity, it's very likely that at some point there could be some liability for those damages that flow from it. And the RWE case in Germany was one of the first ones where the court in Germany commented on litigants trying to sue a private corporation for their proportionate share of the climate damage that has been caused. So even though RWE is a big company that uses coal to produce power, but it was only a very small fraction of a percent of the total amount of climate change. But the court was saying that this is a way to hold polluters accountable because the contribution science of climate change is now becoming so clear, so it becomes evidence and facts. And so then if you can be held liable for your proportionate share of the damage, well, it may be a small share, but it's a huge amount. And so this could start to influence decision makers.
I'd just like to say that in leading up to the appeal, I think what Nancy said about coal kills may be very, very good, to keep getting that message out that this is what this is about. Like it's another 20 years till 2050 coal. And if it, and I think it, from the media I've seen around it and the Narwhal article and so on, you really need to build on that foundation and keep the media's attention as you prepare for the appeal. So, and I think the coal kills is very good. I mean that captures a lot of what this is all about and puts the responsibility directly at Premier Moe's desk.
Just to add to that, Maryo, the Alberta's success in getting rid of coal-fired electricity, I think, was driven most heavily by the health questions rather than climate questions. They were both present, and for Notley, they certainly were both present. But leading up to that already, the health questions really became quite strong.
Great to see you here, John. And yeah, that's why in one of the earlier webinars launching this legal action, where Glenn also was a speaker, we actually hosted, I think I saw her on the call, someone from Cape, and we were in communication with Rhiannon Fox, who is here at least earlier. Maybe she can join us if she's still listening in. On CAPE is the Canadian Association of Physicians for the Environment, and they made their case on why coal kills, standing alongside us, basically as credible of an agency as you can get, speaking on behalf of physicians. And so we will certainly try and amplify the angle of health and equity. And yeah, again, it's all thanks to your support and your help.
And the prevailing winds to get Ontario and Manitoba interested.
Yeah,
the Faith and Climate group, Climate Action Group, actually did a sort of a fake funeral, which was about 50 people. And we had, because of the RBC investments in fossil fuels, and we had RBC kills on this coffin. Yeah. And we had actually a minister leading it. While we were doing a sit-in in the RBC, there was this going on outside and people were singing songs. I mean, that can be quite powerful if it's done in the right place.
Yeah.
Thank you, Brooke. And we do actually have Rhiannon still on the call. So please, Rhiannon, go ahead. From the Canadian Association of Physicians for the Environment.
Hi, thank you. This has been a really lovely presentation, and I really appreciate all of your expertise. It's been interesting to follow along with the legal challenge. So I'm the regional coordinator for CAPE, the Western committees. I support the BC, Alberta, and Saskatchewan committees of CAPE. And CAPE Saskatchewan is working right now on kicking off a campaign calling for an end to coal burning in Saskatchewan using a health lens. So right now we're in the process of meeting with representatives from other organizations to get them on board. We've met with a number of organizations already, including CANE, which is the Canadian Association of Nurses for the Environment, the Canadian Public Health Association, the Saskatchewan College of Physicians, Asthma Canada, and we're trying to meet with several others. And we are putting together an open letter from all of these health-focused organizations, drawing attention to the health impacts of burning coal, largely avoiding climate just because we're trying to make our coalition as broad as possible and speaking more directly to the air quality impacts on people's health. We are tentatively planning on a press conference in May to announce this open letter, and concurrent with that, we'll have a sign-on letter for the general public as well. But just wanted to share a little bit about what we're working on, and please reach out if you're interested in getting involved or have contacts with health providers or health organizations that you'd like to share with me. And yeah, thanks so much. Happy to answer questions too.
Lovely to have you here on the call, and thanks for the work that you do. And I look forward to connecting with you on that work later on in May. And I know there was also another question about defense and military emissions earlier on. I know that is one area that we talk a lot about in the climate movement. One general piece of information is that defense emissions from defense departments are not actually publicly available because they say that could compromise security. And so we don't know how much the Canadian military emits on an annual basis. Neither do we know how much the American military emits on an annual basis, which I would imagine is a lot more. And that continues to be a huge blind spot in advocating in that area, is that we don't know the damage in order to speak against it. I see lots of questions, remaining questions in the chat. If you want, we have less than 5 minutes remaining. If you want to shout out your question out loud, that would be awesome. If there are any last comments by any of the panelists, that would be much appreciated, or else I'll move us into the closing.
I'll shout out one question that I thought maybe would be good for Glenn. Probably is going to be able to answer this way better. But one of the individuals in the chat had asked about carbon capture, and so with carbon capture, obviously they've tried that here in Saskatchewan, and they're not proceeding with a lot of them. But I'd like a more fulsome explanation for the person who put that in the questions in the chat there.
Thank you, Sherry.
So in 2014, the government of Saskatchewan embarked on putting carbon capture on one of the coal-fired power plants here. And as part of the equivalency agreement on the federal coal regulations, all of the plants without carbon capture have to be shut down by 2030, but the ones with carbon capture were allowed to continue on. And we only have one of them. And I think it costs almost $2 billion to put that on there. So it's very expensive. And they tout it as clean coal, but that's really more greenwashing because it still produces an awful lot of emissions. It makes the coal plant almost as clean or maybe slightly cleaner than a gas-fired power plant, but still no way to get us to net zero unless we have some other way to offset those emissions. And right now, I don't see that there is a viable method that's cost-effective or economically possible to offset those emissions. And so right now, I think the government of Saskatchewan and the coal workers from Estevan have been very vocal about us challenging this, saying that we're attacking them personally, we're taking away their jobs. Some of them have threatened to sue back or make a countersuit against CPJ if they lose their jobs and can't pay their mortgages. And some of them are trying to now push the government to put clean coal, this carbon capture on all of the plants. But we know that that's expensive, that it's not actually going to get us to net zero. And we think that there are better options. And that's why we want the record disclosed. We want to know what the government actually considered when they made this decision. Did they look at all of the other options available? Did they have an economic analysis that makes sense? Or is it really just, political interference that's caused them to push SaskPower to make this decision? Because SaskPower had a public consultation that went on for 2 years prior, and nowhere in those public consultations did they say we're going to put carbon capture on more plants. They only talked about adding more renewables or nuclear power or more interties to rely on other provinces. So this really was quite a surprise to see them make the decision that they're going to extend coal to 2050.
Wow. Thank you, Glenn.
Just Glenn, was there any political debate about that before the government said, yeah, we'll take that recommendation?
I've looked through the Hansard minutes of the legislative debates in Saskatchewan, and really it was focused more on pollution pricing and on the clean electricity regulations. So sadly, I think the opposition party, NDP in Saskatchewan, is almost afraid to talk about energy or just to differentiate themselves from the governing party. So they've tended to go along or not challenge the current governing party on anything to do with energy or climate. And so it's really been a very muted response, but they did, push back. I think typically you see provincial governments blame the federal government. So when this idea of the clean electricity regulations was put forward, the opposition and the legislature did all sort of unanimously agree we can't do that. It's just too ambitious. But really, to me, if I look to Australia as an example, Australia now has rooftop solar on about a third of the homes in Australia. And they've got an abundance of solar power between about noon and 3 p.m. So starting in July of 2026, this year, if you have a smart meter, even if you don't have solar panels, you're going to get access to free power from noon to 3 o'clock. So what better way to make affordable energy for everybody when we're talking about an affordability crisis than to encourage rooftop solar? Because if you can imagine getting free electricity for part of the day, well, why wouldn't you charge your electric car then, or do your laundry then, or, even cook a roast or something, right? I mean, it opens up a lot of possibility when you have free power.
Yeah.
Yes, that leads up to a question I have. Is the alternatives to coal not being stressed enough? Are there not options other than coal for producing electricity that are viable now?
Well, that's a dangerous road for us, though, because we're just challenging the administrative decision to use coal. It's not our role as the applicants to say you should do this instead, but we do want the whole record disclosed so we can see that they made a transparent and intelligible, justified decision to choose coal. So really, it's the government that should have looked at all of the various options they had before them. And I think when the government tells us we have no choice but to do coal, I mean, we should be skeptical of that. And that's what this is about. This is about upholding the rule of law and making sure these decisions are justified. And so it's really the government that has power that probably has some studies that said we could use these other options and this is what they would cost. We want that disclosed so the public can see it.
Yeah. Thank you, Glenn. Again, I continue to learn a lot. And thank you, Joe, for that question. Great to see you here, Joe, as well. Thank you for that question. Certainly not enough is being done on exploring alternative renewable sources of energy in Saskatchewan. But as Glenn said, the scope of our legal challenge is limited to challenging the use of coal. We're almost at time, so I'll offer a brief closing. First of all, thank you again, Glenn Wright and Roger Townshend and John Olthuis. I'm honestly very grateful to be in a conversation with you, sharing the same platform. The public interest legal work that you've done and continue to do is part of why CPJ and so many communities keep pushing for justice for all. And second, 3 quick action steps. Please sign the open letter. Again, we'll share the links in the chat, which calls on federal government to end the equivalency agreement, which enables the burning of coal in Saskatchewan and prolong coal-fired electricity. And so we'll drop the link. Please consider signing up for CPJ's monthly newsletter, Justice e-News, so you can stay connected to the work that we do and future actions and never miss an event like this or a publication. And if you're able, and thank you, Glenn, just very quickly, thank you, Glenn, for highlighting the stakes of this legal challenge as well. Not only are some of the coal workers threatening to counter sue and get their lost wages from us or sue CPJ as the applicant in this case, but also the government has already sought costs against us, meaning the government asked the judge in the first trial hearing that they basically that we pay for their costs, for their legal costs. And luckily, the judge did not think that was warranted, but we don't know moving forward whether the government will continue holding on to that position, and if they ask for us to bear the legal costs, then we will have to foot that bill. So brings me to my last point. If you are able and it doesn't constitute a huge financial challenge for you, please consider donating to sustain CPJ's work and to future-proof our legal challenge at the No More Coal challenge. No More Coal in Canada. Maybe we actually need to rename it to Coal Kills, like Nancy suggested. Because if I can't remember the name of the campaign, then probably not a good sign. But No More Coal in Canada campaign. Please donate if you're able. We do work, including the legal challenge, public education like today. and the advocacy that continues long after the webinars end. So finally, strategic litigation is just one tool, but public momentum, here's what I was talking about earlier, moral clarity and organized community pressure are tools too, and we have all of them, and they scale. So please join us at Citizens for Public Justice as we scale this forward momentum towards public justice for all. Thank you all for taking the time, and I wish you a very, very lovely night. Thank you.
Thank you.
Take care.